Good morning, everybody. This is Erik Daly speaking from Miller Johnson. I am a partner in our corporate and business group, and today we will be talking about the CARES Act again. And this is a sequel to a webinar that I did with my partner Keith Eastland, who is not on the line with us today. He's doing fine, but he's not going to be addressing the topics in today's presentation. So this is part 2 of the CARES Act by the Numbers webinar, subtitled What We Know Now. And just so people in the audience know, we will be focusing almost entirely on the Small Business Administration's Paycheck Protection Program information, and not as much, if at all, on other aspects of the CARES Act, which would include tax-specific issues, unemployment-related issues, CISA-related issues. We will continue to address those in our other webinars, but because of the immediacy, and we'll get to this momentarily, of some of the timeframes relating to small businesses participating and applying to participate in the Paycheck Protection Program, we decided to focus this webinar exclusively on that topic to get some additional information out there based on materials that were released yesterday by the SBA and Treasury, and based on some further questions and conversations that we've had with clients, with bankers, with other people involved in the SBA ecosystem, if you will. But before we get into the presentation, I always like to start with a reminder that we're working collaboratively with the community of businesses, government, other advisors, not-for-profits, and really the community at large to try to do our best to contribute to the efforts to weather this really unprecedented storm of a situation that seems, unfortunately, to escalate in new and unpredictable ways each day. And as we pursue our contribution to those efforts, our daily guiding principles are collaboration, ingenuity, intellect, and candor. And so with that in mind, and with the preliminary comments out of the way, I won't be offended if some people who want to drop off because they're not interested in the SBA's loan programs. If you need to drop off, there's no offense taken, and we will continue to have webinars on other topics that may be more germane to your areas. But let's jump into today's numbers, the CARES Act by the numbers. These are all going to be small business loan related issues. So the first one, I'm getting creative here, I think, with some of the quote unquote numbers, but first one is 4/1, April 1st, today, obviously. If you're a small business, today is Contact Your Bank Day, not April Fool's Day, and we'll get to that in a minute. 4/3, April 3rd, Treasury and SBA are aiming to have the Paycheck Protection Program up and running through banks and credit unions by April 3rd, so by Friday, to be able to start accepting and potentially even processing and funding some loans under the PPP program. Third number, 2 years /0.5. We learned from the press releases and materials put out by Treasury and SBA yesterday that all PPP loans will have identical terms of 2-year maturity and a 0.50 basis point fixed annual interest rate. The only variable across loans will really be the size of the loan under the PPP program. 25%. This is a new potential limitation and something that clients will need to factor into their math as they're thinking about forgiveness under PPP. The materials put out yesterday say that it is anticipated that not more than 25% of forgiven PPP loan amounts may be for non-payroll costs. So those would be things like mortgage, utilities, rent. The guidance put out yesterday is indicating that no more than 25% of your forgivable loan could be for those categories of permissible and forgivable uses. So that would be a new restriction or a new limitation on forgiveness. The next number is the $100,000 number that relates to payroll cost calculations. And there was some clarity provided here about amounts below 100,000 still counting toward your overall determination of payroll costs. But I think there's some new ambiguity about that calculation, which we'll get to later. It's really more than three, but there are going to be three new representations and certifications that are in the sample application that SBA and Treasury released late in the day yesterday that I'll touch on, but there are more, three of particular note. And then 2019's last number we'll touch on, and that is included because the sample application for the PPP loan that was put out by Treasury and SBA states that many applicants will calculate their payroll costs based on calendar year 2019. That would be a deviation from what's included in the statute itself, which says that you would calculate payroll costs based on the 12 months prior to the loan, which wouldn't, of course, be calendar year 2019. So that's what we're going to hit on, and then we'll touch on some other considerations, notes that I thought were worth highlighting, but didn't roll up neatly into numbers at the end of the presentation. So next slide, please. Okay, so before jumping into the numbers, this is just the summary. If you didn't participate in the webinar that Keith and I did on Monday regarding part one of CARES Act by the numbers, and you're interested in potentially pursuing a PPP loan, I'd encourage you to either download the slides, which are available. You'll get a link in the post-webinar emailings about where to download previous slides and watch previous webinars, but I would request, suggest that you watch that webinar to get more detailed information about a number of these things. But this is a quick overview of the PPP loan scheme. It's a temporary form of a Section 7A SBA loan. The size of the loans for any particular borrower would be equal to 250% of that borrower's average monthly payroll costs. So it's meant to be, I guess, really about 10 weeks of payroll costs. I think it's one way to think about it, is the amount of the loan. The maximum loan size is $10 million per borrower. The overall amount available under the program is $349 billion, with no more than $10 million per borrower. There are no personal guarantees and no collateral required for these loans. There's no credit elsewhere testing, so you don't need to show that you were unable to obtain a loan from another source or another lender, which would typically be a case for SBA loans. There's no principal, interest, or fee payments due for the first 6 months. Statute itself said that could be for up to a year, but in the guidance we got in the press release from Treasury and SBA yesterday, they announced that the loans would uniformly have this 6-month period of of deference of principal, interest, and fee payments. So it won't be up to a year, it'll just be 6 months. There's still no fee to apply or process the loans, no prepayment penalties, and they may be used to refinance recently incurred SBA disaster loans, or EIDLs. So that's the overview. Again, the details of the statutory language and what we knew before Treasury and SBA put out their guidance. You can look at the slides and watch the webinar from Monday to get a more detailed analysis of that. So next slide. Okay, April 1st. Again, not April Fool's Day for small businesses. If you haven't already contacted your bank, this is Contact Your Bank Day. Ideally, the bank that you have pre-existing lending relationships with, or where you have contacts who you've worked with in the past, who can work with you as an existing and prioritize you as an existing customer or depositor of that bank. You want to ensure, though, that that bank is already an approved SBA Section 7A lender or is otherwise eligible to process loan applications immediately on April 3rd. April 3rd, this system is going to go live at banks that are already approved SBA Section 7A lenders and certain other banks. So and financial institutions. So you just want to validate that your bank is going to be able to accept an application on April 3rd. And if they're not, consider whether you go to another bank that is already, or a credit union or financial institution that is able to process these loans as soon as possible. And then confirm, I guess, if you still want to work with another bank that won't be processing applications immediately on April 3rd, confirm when they will begin accepting applications. And you want to verify what specific information your bank, credit union, or financial institution is going to require. The guidance and releases yesterday from Treasury to SBA lenders, so the communication that they provided to lender participants in the PPP scheme said that the lenders, you lenders, will need to verify the dollar amount of average monthly payroll costs. So there is some verification that is going to need to occur on the lender side or the bank side. And you want to know exactly what the bank is going to need to verify your average monthly payroll costs. Next slide. Okay. Next number is 4.3, April 3rd target. Already touched on this a couple times here, but in the materials that were released yesterday, Treasury and SBA announced that their aim is to have banks processing PPP applications, or at least existing 7A approved lenders and certain other institutions processing these applications, having them up and funding by Friday, April 3rd. And that April 3rd date is for small businesses and sole proprietorships. It's not clear if that would be also the date for not-for-profits. They weren't specifically mentioned, but my assumption is that it will be. So if you're a not-for-profit and wondering if you're going to be able to apply on April 3rd, again, I would make sure you ask that question of whatever bank you might be working with. They may not know the answer yet because it wasn't clear from the materials put out yesterday, but hopefully it will become clear. The materials say speed is the operative word. That's, again, the overall goal of this policy is to get the loans and the funds from the loans out into the hands of small businesses as quickly as possible. And I think that may explain some of the other issues we'll get to in terms of disconnects between the materials that were put out and the language in the statute itself. The goal is to have banks and credit unions be the single point of contact for PPP borrowers so that they're not working through the SBA itself, but they're working with financial institutions. And then the SBA is really just in the background guaranteeing the loans and not actually processing loans or accepting information from from would-be borrowers. Their role will be, the SBA's role will be interfacing with the banks and credit unions sort of behind the scenes to provide a framework for validating participation and providing guidance, but not actually processing loans. And then this last bullet point here, April 10th is the target date for independent contractors and self-employed individuals to be able to participate or to be able to submit applications for PPP loans. So you've got April 3rd for small businesses and sole proprietorships, and then April 10th target date for independent contractors and self-employed individuals and gig economy type folks. So with speed being operative, things are going to be a little slower, I guess, unfortunately, for independent contractors, self-employed, and gig economy workers. The next slide. So continuing on this theme of speed and the April 3rd target date, in the FAQ materials put out by Treasury and SBA, and this addresses some questions that we frequently have received from clients. One of the specific FAQs is, how long will this program last? And technically, under the language of the statute, it lasts until June 30th, 2020. And so it says, the answer is, although the program is open until June 30th, 2020, we encourage you to apply as quickly as you can because there is a funding cap and lenders need time to process your loan. So a frequent question we've gotten is, how will these loans be processed? Is it sort of a first in, first funded type of situation, or is there some prioritization based on industry or NAICS codes, or based on number of employees or some other criteria? I don't think we have a definitive answer to that question at this point still, but clearly Treasury and SBA are emphasizing that there's a limited amount of funds, and the faster you can get your application in, obviously, the better chances that you'll be approved for a loan. So that ties back to today being Contact Your Bank Day, if you haven't already. And then it's unclear again how the April 10th date for independent contractors and self-employed individuals, how they will be affected, given they have a 1-week delay in being able to apply, and yet there's guidance to get in as quickly as possible. So that could be a handicap in the process for independent contractors and self-employed individuals. Next slide. Okay, so we touched on this before. This relates back to the 2 years and 50 basis points numbers. The PPP loans they've announced will be on identical terms for all borrowers. So all PPP loans, even though the statute, the CARES Act itself, provided flexibility for there to be up to a 10-year term, I believe, and up to a 4% interest rate, and potentially up to 12 months of deferral payments. I think tying this back again to getting the money out as fast and as quickly as possible, they made the determination that to reduce the amount of those types of decisions that would need to be made before getting funding out, that they're just going to fix the loan terms at identical conditions and terms across all borrowers, so that there's less administrative delay or determinations being made before the loans are approved and funded. So everything's 2-year term. Again, everything is 0.5% fixed interest rate. It's not going to escalate up to 4%, which would be the max under the statute. It's going to be fixed at 0.5% during the term of the loan. First, any kind of payment requirement, again, deferred for 6 months. Still no collateral guarantees required, and still no fees, processing on the front end or prepayment later. And again, the only variable will be the size of the loan for each borrower, regardless of what type of borrower you are, small business, not-for-profit, independent contractor, sole proprietor, et cetera. Next slide. Okay. Next number is this new 25% number as a cap on non-payroll related forgivable expenses. And just before jumping into that, there's another 25% figure that you might be thinking about if you've been following the SBA's PPP guidance or our webinars, and that 25% number relates to salary reductions, and that is a different 25% number than we're talking about here. So that 25% number related to potential wage and salary reductions for employees during the covered period for these loans, that is unchanged, at least with respect to the materials that were released yesterday. But this is new 25% number in addition to that in another context, which is, and I'll just read the language that was included in the materials. Quote, due to likely high subscription, at least 75% of the forgiven amount for a PPP loan must have been used for payroll. And that is a new potential limitation compared to the language in the CARES Act itself. The CARES Act did not distinguish at all between the potential forgivable uses of loan proceeds. So theoretically, a borrower could have used more than half of the loan proceeds for rent, utilities, and mortgage payments. All of those are identified in the statute as forgivable expenses and still had those amounts forgiven when they go to settle up the loan with their lender. However, now the application materials and the FAQs are saying, actually, because we're anticipating that $349 billion may not be enough or will not be enough, more realistically, we want to ensure that at least 75% of these loan amounts are being used for payroll and kind of making their way to the employees rather than for those other forgivable expenses that the statute said could be eligible for forgiveness. And again, those would be rent, mortgage, and utilities generally. So bottom line here is that if you have been running your math on the assumption that you might be able to use more than 25% of these loan proceeds for forgivable use that is not payroll cost, so mortgage, rent, and utilities, you're going to want to rerun your math, or even if you think it's a close call, just rerun your math and make sure that if you're trying to maximize forgiveness, that your assumptions or your modeling of this doesn't result in you, the borrower, having more than 25% of your forgivable expenses being a non-payroll cost bucket collectively. So all put together, mortgage, rent, and utilities should not be more than 25% of your forgivable amounts, because now they may not be forgiven if they exceed 25%. So that's a very new and important consideration for borrowers. Next slide. Okay. $100,000 is our next number. This ties back, if you've been tracking the progress of this PPP scheme, you might remember that when you're calculating your loan amount, you tie that to your average monthly payroll costs. When you're calculating your average monthly payroll costs, you're looking you basically your prior year period, although now it may be calendar year 2019, looking at for all your employees, adding it up, and then for certain employees, highly paid employees above $100,000, excluding their compensation above $100,000 from that average monthly payroll cost calculation to determine what, for two purposes, to determine what loan amount you will be eligible to receive, and then also for how you can expand, how you can use those funds once you have them, and still receive forgiveness. So in the materials yesterday that were released, there was some helpful guidance, I think, provided implicitly at least, that the amounts below 100,000 in payroll costs or compensation for employees who would otherwise have a figure above 100,000, those still count as permissible payroll costs when you're calculating your maximum loan amount. So there had been some questions about, do you exclude those people altogether from the calculation, even the amounts below 100,000? We were of the view, and I think most, attorneys, accountants, and others were of the view that no, you don't exclude them altogether. You still get to count the amount below $100,000. And it turns out, yes, that's the right view. But what is still, or what is now unclear or more unclear based on the materials put out yesterday, is what that $100,000 amount is applied against. Is it applied against just salary, wages, and commissions and tips? So just kind of your salary compensation, or is it all of the components of payroll costs, which would include things like, employee health care benefits, certain state and local taxes, potentially, severance type costs, the other litany of things that are included beyond salary, wages, commissions, and tips that are part of the payroll cost definition. The information put out yesterday is seemingly contradictory on my reading on that point. There's some language that suggests that it would apply to kind of your full amount of payroll cost, the fully burdened expense, so that you'd only get to count up to 100,000 on the full figure. And then there's some other language in there that suggests that it would really just be that portion related to salary, wages, commissions, and tips. Our reading of the statute is that it's pretty clear that the $100,000 limit only references salary, and so it would be better reading to apply it to salary, wages, commissions, and tips only, and not all other payroll costs. But at the end of the day, what's going to matter here is what the banks are told by SBA, and I think they're probably going to need more clarity on this, because the onus will be, as we talked about earlier, on the bank, credit union, or other financial institution to validate average monthly payroll costs. So if I were a bank who's going to be in the position of needing to do that on Friday, I would want more clarity on what that $100,000 cap applies to. But at least now we have clarity that the amounts below $100,000 still count toward your average monthly payroll costs. And this is all on an annualized basis. So you've got to factor that into your forgiveness, because your forgiveness period is only 8 weeks after you take out your PPP loan. And I think this is also making it clear that those amounts below $100,000 will also be forgivable during that 8-week forgiveness period on a pro rata basis. So reducing 100,000 from an annual figure down to an 8-week period. Next slide. Okay, the next number was 3+, and they're really more than 3. at least in the sample application, that loan application that was put out by Treasury and SBA, and 3+ new representations and certifications that we wanted to call out, these 3 in particular, but there are more. Again, in the sample application, we'll see if the sample application ends up being what banks actually use. I think just very early anecdotal feedback is that it may not all translate ultimately into the final applications, but for the materials that, if you're going onto the SBA website and looking at, okay, what does the application look like? You're getting a sample application that includes the following certifications or representations. First, to the extent feasible, I will purchase only American-made equipment and products. That came out of nowhere. There's no reference to that anywhere in the CARES Act. And it's even more confusing because PPP loans, I'm having a hard time imagining a permitted use of a PPP loan that would be for equipment or products, because again, they're generally things like payroll costs and the like, utilities, mortgage and rent that you would typically be using these expenditures for. So at least to get forgiveness. So it's hard to think of, American-made equipment and products being something that, most borrowers would have been using these loans for anyway. And yet, in the sample application form, you must state that to the extent feasible, whatever that means, you will purchase only American-made. Again, not sure exactly what that means, given that there's a whole supply chain that would go into producing any equipment or products. There's no time limit. There's no, presumably this is just during the term of the loan, if this representation is included in the final materials, and presumably, once you've paid off your loan, this is no longer applicable, but it's unclear whether this only relates to the loan proceeds or if this is just an overall requirement for your business for being a participant in the PPP loan scheme. So there's a lot of open questions on this and whether this will ultimately be included. Again, this is a totally new condition or representation if it is included ultimately in the bank application documents. The next one that I wanted to call out is, again, these are all in the sample application that's available online now through Treasury and SBA, but this one says all SBA loan proceeds will be used only for business-related purposes as specified in the loan application. And we'll touch again on this later, but the loan application requires you to indicate, at least in the sample loan application, requires you to indicate what you will use the loan proceeds for. So the level of detail that you might need to provide there on the front end when you apply is more than I think, at least I anticipated, and probably most people anticipated. If you're only going to be able to use the proceeds for what you specify in the loan application, that obviously would give you less flexibility to then adapt, 4 weeks into your forgiveness period, change course and use the loan proceeds for some other forgivable purpose or permitted purpose. So this seems to suggest you need to know on the front end. And I guess from the SBA's perspective, I can understand wanting to know that information on the front end as banks are approving or declining loans or making judgments. They want to understand what the loans are going to be used for, but a representation or certification that you will only use the funds for those purposes that you specified in your application is going to, if ultimately enforced or included in the final materials, will hamper your ability to be flexible. And I can't imagine that at the end of the day, there's going to be a lot of non-forgivability if you just shifted buckets subject to that 25% limitation referenced in the bullet point below that we already discussed for non-payroll costs. but it's something to be aware of and to be looking for in your applications, is that you may, that what you describe in your initial application may end up being kind of a roadmap for how you can use the proceeds and with less flexibility than originally anticipated. And then the last thing I want to note on representations and certifications for now is that, again, in the sample application, many certifications must also be made by all of the 20% owners of the business, even though 20% owners aren't required to be guarantors of the loan as they typically would be in the SBA loan context. They would be required to actually go through, complete, sign, and date certain portions of the loan application, which just, one, logistically could be tricky for some people, but two, could, because of the nature of the certifications and the new requirements, it could disqualify certain borrowers. So let's keep moving. All right, I alluded to this already, but 2019 payroll costs. The materials released yesterday state that many, and I'm paraphrasing here, but it essentially states that many applicants will calculate payroll costs based on calendar year 2019 data. On the one hand, this may be more feasible to administer for some borrowers, just because obviously calendar year periods, it's maybe easier to tie a bow around those and have the right backup information more readily available. But it is inconsistent with the language in the Act itself, which references the 12-month look-back period from the date of the loan itself. So there could be this could positively or negatively impact a particular borrower if you were able to use calendar year 2019 data. On the one hand, that would exclude, March, which for some companies, if they've laid people off, could be a lower payroll cost month. And so you'd have more of a quote unquote normal year if you used 2019 data compared to a trailing 12-month period. On the other hand, for some businesses, if they had paid incentive comp or bonuses in, say, January or February of 2020 that were higher than what they paid in 2019, it could be negative. So it could be detrimental to the calculation. So I think you probably still have the flexibility to do either. But again, this is another thing where you're going to want to work with your bank or your lender to, and I know a lot of you have already been crunching the numbers on these things. If you are allowed to use calendar year 2019 to again, rerun your numbers, see if that might be more favorable in terms of an average monthly payroll cost calculation. And if you are allowed to use that, then, that would be favorable in terms of getting a greater loan amount. Next slide. Okay, so those are kind of the numbers, quote unquote, that I highlighted at the beginning of the presentation. But in reviewing the materials that were released yesterday, there were just these are called other new considerations at the heading of the slide, but it's sort of odds and ends. And some of them are pretty important odds and ends, so we'll go through these. The first is the sample application requires a detailed listing and description of all affiliates and affiliate relationships. And this is a very broad affiliation, as we discussed on Monday, is a very broad concept in the SBA world. It can be based on ownership, can be based on overlapping management, it can be based on joint ventures, financial ties between organizations, contracting and subcontracting arrangements. So I think what they're focused on mainly in the PPP application would be affiliation based on some of the other information that is included in the application, would be affiliation based on cross ownership and director and officer positions in the first instance, but you know, I would be of a mind to think broadly about affiliation if and when you have to respond to that question, if it's ultimately included in the final applications, because there's nothing in the CARES Act itself that would require this disclosure to a lender in order to get a loan. The CARES Act itself required very minimal certifications and disclosures. So this is a new requirement if it's ultimately included in what the banks need to get from you. So one thing you can do now, though, unless you're able to get a straight answer from your bank about whether they're going to need this, would be to, if you don't already have this information from your major owners, directors, officers, is to figure out what other businesses might trigger affiliation disclosure. And another thing to think about here, probably a secondary consideration given the circumstances, but for certain of your investors, for some types of businesses, there might be confidentiality restrictions in place on disclosing the fact that they are an investor in your company or a part owner of your company. So if you've got a 20% owner in an agreement with them that you're not going to disclose to anybody that they're an investor, that creates a problem where you've either got to disclose it or potentially in violation of the non-disclosure agreement or not included on your application, which would disqualify you or potentially subject you to penalties for not disclosing it. So just something to be thoughtful about. Okay, the next couple are new triggers for automatic rejection of an application based on items in the sample application, which are totally new and rather broad compared to the CARES Act itself. So again, we'll see if this ends up being included in the final bank application materials, but at least the sample application states that you will be rejected if any applicant, if it's presently involved in any bankruptcy. If you're in a bankruptcy proceeding, this sample application says you will be rejected. It also says, read literally, that if any owner of the borrower is involved in a bankruptcy proceeding, that you'll be rejected. So if you have a stockholder through no fault of the business that is in a bankruptcy, the sample application read literally would disqualify that borrower from getting to participate in the PPP scheme. So if this is included, it's just another thing where you gotta, I guess, go out and somehow confirm that none of your owners are in a bankruptcy proceeding. And if you have a more closely held company, that might be easier. But if you have a lot of investors, that's obviously going to be a little bit trickier to be able to certify in a loan application. Similarly, the application states that it will be rejected if the applicant, so the borrower, any owner or any other business owned or controlled by the applicant or any owner has defaulted or is currently delinquent on an SBA-backed loan or other government-backed loan in the last 7 years. So again, you have to certify that if this works its way into the final application, that neither the borrower or any owner or any other business owned or controlled by the borrower or any other owner has defaulted on an SBA-backed loan or another government-backed loan. And there are a lot of government-backed loans out there, you know, mortgages and a lot of, so that's another very broad potential trigger for rejection. And I just don't know if that's going to be included in the final materials that your bank uses. If it is, it's a very tricky thing to certify again if you have a closely held, unless you have a very closely held business. Next slide. Okay, this first bullet point, not unexpected. You have to disclose any recent SBA disaster loans that the borrower has received. These are the EIDLs that you may have heard of, or that if you've watched the webinars, you've heard us talk about, the emergency injury disaster loans. You have to disclose that, but there's no new guidance here on whether you can use both EIDLs and PPP loans together. In other words, apply for both. On the strict reading of the statute, there's nothing that would restrict you from doing that, especially if you applied for the EIDL before PPP loans come online. And no matter what, if they determine that that you can apply for both, it is clear that you would not be able to use the loan proceeds across those two programs for the same purpose. But there's no more clarity on kind of that threshold issue of whether you can apply for both even after PPP loans come online. Okay, another couple of automatic rejection triggers, according to the sample application at least, would be if any 20% owner is currently subject to criminal proceedings, incarcerated, or on probation or parole, or has been convicted or pleaded guilty to or incurred similar sanction for a felony or a misdemeanor against a minor in the last 7 years. So here's another thing that wasn't included in the statute at all. And if you look at the language, and I've paraphrased it here for the presentation, but basically the first of these sub-bullet points, you don't have to have been found guilty or pleaded guilty or been convicted. This is just you're subject to criminal proceedings. If you're a 20% owner, that's a very broad, again, potential trigger for rejection of an application, not based on the borrower itself, but based on a large owner. So another thing, this one is, I guess, a little bit easier to verify since it's only applicable to 20% plus owners. But, if you have somebody who has any kind of criminal proceeding currently or in the last 7 years, had a felony or a misdemeanor against a child, that's something you're going to want to be aware of, because if this works its way into the final applications, then that could be disqualifying. All 20% plus owners must be U.S. citizens or have lawful permanent resident status. That's a new requirement that's not included in the Act, but is included in the sample application. And borrowers must recognize that by applying for a PPP loan, they are agreeing to remain in, quote unquote, remain in compliance with all applicable workplace safety.
All right, folks, looks like Erik's phone just got disconnected. We'll try to get him back here in just a second.
Hi, this is Erik. Hopefully you can hear me again. I got disconnected.
Yep, Erik, we can hear you.
Somehow.
Thank you.
Great. Sorry about that. I don't know what happened. My phone glitched out all of a sudden, and glad to be back. So I don't know where I got left off, but I think we were on this last bullet point about just borrowers, you need to recognize that they must remain in compliance with all workplace safety standards, so OSHA standards, really, during the life of the loan. Jeff, does that sound right? Is that around where I dropped out?
I'm not exactly sure, but I'm sure we'll roll the punches.
Okay. Okay, why don't we go to the next slide? Those other ones speak for themselves anyway. Okay, thank you. Other new considerations, we touched on this first one earlier. You must disclose the intended uses of loan proceeds upon application, according to this sample application, which could potentially lock you into to certain uses of those loan proceeds. The sample application does not ask for NAICS codes, which I think is something that they're going to have to fix, because it's clear in the statute and some of the other guidance that they put out that some businesses will be eligible for a greater employee headcount above 500 based on their NAICS code while still being eligible for a PPP loan. So that information needs to be solicited or provided somehow. And I didn't see on the sample application where it was solicited or requested or was able to be disclosed to justify more than 500 employees. And then last on this page, on this slide, the last point I would call out is that in light of potential detailed affiliation disclosures in particular, I would note that the SBA is subject to the Freedom of Information Act. And the fine print in the sample application, anyway, states that the following information might need to be provided in response to a FOIA request. And it says that other information could be things such as the names of the borrowers, so who's getting a loan, and their officers, directors, stockholders, or partners, the collateral pledged to secure the loan, the amount of the loan, its purpose in general terms, and the maturity. And I want to just focus on that parenthetical about officers, directors, stockholders, and partners. So tying this back to the application process, you need to disclose all this affiliate information if you have affiliates as part of your loan application. You might be borderline on a confidentiality restriction on that disclosure, and then it potentially could be subject to a FOIA request and response. So, you know, when you're disclosing your affiliates, again, this is something to be mindful of. If you do have understandings with certain investors or stockholders that they are not going to be publicly disclosed as being investors in your company or your entity, this FOIA issue and the disclosure requirements could be a way where, you know, an enterprising person could discover, you know, who your investors are if they're significant investors. So just something to be aware of. Next slide. Okay, an enforcement reminder. The sample application is very clear that if the PPP loan funds are procured, you know, or utilized impermissibly, so you provide false information or then you use them for a non-permissible purpose, then the government is retaining its full ability to pursue significant fines, civil and or criminal charges. We knew that already based on the statute, but it's just emphasized again in the sample application, and it's an important reminder as, you know, people are going to be making these applications quickly because of the speed issue that I referenced earlier. But on the other hand, you got to be mindful that you're providing correct information and then utilizing the funds permissibly, just, you know, especially for material factors in the applications. The next slide. So some concluding remarks before we do Q&A. The materials released yesterday by Treasury and SBA, at least in my opinion, create a good deal more uncertainty and generate new questions based on some of the new certifications, requirements, automatic rejection triggers that are included in the sample application, and really only provide clarity on a few of the questions and ambiguities that we were getting the most questions on previously. So for better or worse, the program is moving ahead quickly, and I think that is consistent with the goal of getting funds out to small businesses rapidly so they can then be used for payroll, which is the kind of policy behind the program. But you know, on the flip side, there's just going to be a good deal of uncertainty because of that urge for speed around some of the more legalistic or, you know, accounting questions that come up as you're trying to run the numbers on things or make sure you understand affiliates and respond accurately to the applications that are ultimately put out there by the banks and credit unions. Before turning over and looking at some of the Q&A that we've got lined up, just a final reminder, contact your bank if you haven't already, because Friday, apparently for small businesses and some others, sole proprietorships is when, when this is going to come online. So get out in front of your banking relationships to the maximum extent that you can. All right, I'm going to toggle over to the Q&A here and answer questions that I can. Thank you for bearing with us through that couple of minute technical glitch if you're still in the audience. So I'm doing this fly. My company is owned 100% by a foreign corporation. Would we qualify for the PPP? You're going to have to disclose that affiliation. They're obviously an affiliate if they own 100% of your business. And they probably have, I'm guessing, other companies that they own. And so when you start working with the affiliation rules, my guess is that you're going to end up, I don't know about this individual's business or the parent company, but that because of the affiliation rules and the fact that you need to certify that none of the 20% owners is, according to the sample application anyway, you have to be either a U.S. citizen or a permanent resident status. I'm guessing no, that you're probably not going to qualify, but that doesn't mean you shouldn't talk to your bank, because they say that these are all guidance and sample materials, and the rubber is going to really hit the road with working through these issues with your bank. But that seems like a situation that is unlikely to qualify. Our business is seasonal, but we are unsure if the SBA would classify us as a seasonal employer. We do employ year-round. How do we determine? The administrator, so the SBA itself is going to determine what is a seasonal business. I don't have a good answer for that right now, unfortunately. I think hopefully in the application materials there will be a self-certification of seasonality, and then I don't think they're going to hold up getting money out based on kind of a legalistic assessment of whether a business is seasonal or not. I could be wrong about that, just because there's no guidance provided on that point. So again, that's the one where the banks might get more guidance, but nothing put out there publicly or that we've seen has answered that question. I'm just trying to look at the questions that might have broadest applicability. So in the calculation of the loan amount, do we cap high earners at $100,000 over a 12-month period, or are high earners full earnings included in the calculation? Cap them at $100,000. The only remaining open question there is whether that $100,000 is just wages and salary type compensation, or if it's also benefits and other categories of payroll costs. But their full earnings would not be calculated, would not be included. Here's another good question, which we don't know the answer to, but it's a good question and that we've thought about. If I apply now, can I wait to utilize the funds, i.e. start my 8-week period? Can the start date be as late as June 30th, or is that when the 8-week period must end? So the loan could be taken out as late as June 30th. So that's not, according to the statute anyway, and that's not when the 8-week period must end. You could apply later and start your 8-week period later. What we don't know is whether you can apply now, get approved, and then wait to accept the loan until an optimal time for an 8-week period. That is I think our operating assumption is probably not, but we'll see. It's possible that that will be the case, which would afford more flexibility for people trying to time the 8-week period to coincide with a period during which they would have the most forgiveness. I'm going to take a couple more questions. I know we're just a minute over the 1 hour, but I see we still have a lot of people in the room. Who needs to sign if you are a not-for-profit? Based on the sample application, I think it would really just be the sort of the executive director or similar position of a not-for-profit. And only 501c3 and certain veterans not-for-profits even qualify for PPP loans. I don't think that 20% owner concept is going to apply, but some affiliation concepts may. So that's just an issue to work through with the bank if they're going to need any additional signatures based on the nature of your not-for-profit and who's involved on the board and things like that. If you still have revenue coming in, can you use these loan funds to pay employees versus other existing revenue? Yes. These loan funds should be used to pay employees, even if you have, well, you could use other revenue, but really the purpose of this program is to pay employees. That's the main thrust of this program, and that's emphasized again in some of the guidance about capping other expenses at 25%. So yes, you could use these loan funds to pay employees versus using other revenue if you still have other revenue coming in under the PPP program. If uncertain if affiliate rules would prohibit a PPP loan, should we just make an application with the bank and let the process vet out eligibility? I think that's a good question. It's not really a legal question in my mind, but more a practical question about how you want to spend your time and resources, knowing that so one, if you do make the application, make sure you disclose all the affiliation issues that the application requires, and just understand that that may ultimately put you in a category where, with the affiliation rules applied, your employee headcount is too high to qualify for a loan, and you may have spent those time and resources, trying to get a PPP loan that you don't ultimately qualify for. I'm going to try to respond to 2 or 3 more questions before we conclude. A lot of good questions in here. And frankly, the ones I'm not answering, many of them we just don't have answers to. And there are things that are going to have to be worked out with the banks during the application process. What box do we check at the top of the application if we are an S Corp? If you're still otherwise a small business, you would check the small business box, which I believe is, let's pull up the application form, but I believe that is one of the boxes. So you don't need to specify on the sample application form whether you're a C Corp or an S Corp. You don't have to distinguish between those 2 things. It would just be a small business as opposed to a sole proprietorship. What is the start date of qualified payroll payments? I assume that question is referring to the start date for forgivable payroll payments. And the start date is the date you get your loan, and the end date for forgiveness is 8 weeks after that. So it's an 8-week period from the date you get your loan to the end of that 8 weeks. If we are currently working with 2 banks for loans to get us through the pandemic, should we select one bank to work with us on the PPP application or both submit an application? Good question. You should just submit one application. One of the certifications is that you do not have multiple applications pending for duplicative funds. So no, you should not submit applications through 2 different banks, but you should work with the bank that is best positioned to vet the information about payroll costs based on what they're going to require, and then to process the application so that they're already an SBA approved lender, for example. On the sample, there's a question that's come up internally in our discussions over the last 18 hours. On the sample application is the number of jobs. There's a portion on the, people have seen the sample application will see that it's got a box, number of jobs. So the question here is that referring to the number of full-time employees at the date of the application? I think what that's referring to is, one, it wouldn't just be full-time employees. For the SBA employees, and clearly under the statute, it's full-time or part-time employees. I think that is meant to elicit information about total number of full and part-time employees for purposes of the 500 or potentially higher, depending on your industry, employee test. And for that purpose, you're not doing full-time equivalents, you're just doing the total number of full and part-time employees. So that's how I interpret that box, but sound like a broken record, but we'll see how that works itself out with the banks. And then we're over. So I'm gonna have to leave, but this is the last question for now that we'll take, but a lot of good questions. Thank you for submitting them. We are a C Corp with a wholly owned subsidiary. Should each company apply for a PPP loan or just one loan under parent corp? I would advise just one loan under the parent corp, because clearly if it's a wholly owned subsidiary, it will be an affiliate. And I think your disclosure requirements will probably, well, I guess, depending on what the final application form looks like, I suppose your disclosure requirements might be eased somewhat if you use a subsidiary, because then if you have to disclose all the stockholders, it's just the one parent corp. But I think if you use the C Corp as the borrower, it might give you a little more latitude on how you ultimately use the funds and get forgiveness. So there may not be a one-size-fits-all answer there, depending on your capital structure and what exactly the application requires disclosure of in terms of indirect ownership. But in general, I think probably the parent company. So I'm sorry I didn't get to all the other great questions that were submitted. I'm sure there will be many more that come up over the next days and weeks. And I've mentioned a lot, talking to your bank, which I think is critically important, but, we can also help work through issues that come up that are more legalistic, like affiliate determinations, and making sure that you understand terms in the applications. And I know you're going to have to balance that. We all are against the need for speed in the application. So, feel free to reach out. We've got a team of people, not just me, at Miller Johnson who are working, who are up to speed on this legislation and reviewing all the guidance and materials that come out. So you may have worked with other people in Miller Johnson like Max Barnes or David Hall or Dustin Daniels. Really the four of us, along with other people across groups, are coordinating the most on vetting and then collaborating to make sure we're comparing frequently asked questions among one another so that we can share that knowledge and share information we're getting from our contacts in different banks with each other. So feel free to reach out to any of us, and thank you for attending today. Hope you have a great day. Thank you.